well, we'll do this and then we'll take a break.
Sarah.
All right, court is calling 2025 CR 005466 State versus Lindsay Terriano. Do I have parties announced?
For the state of Texas.
Brian Kimbrough from Mr. Toriano.
Are you Mr. Terriano?
Yes, Your Honor.
All right, you entered into a plea. According to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. The state is opposed to your applications. They're taking in consideration 2025 AL 007223, 2025 CR 010071. There's an affirmative finding of family violence and no contact with the complainant. Have both parties had a chance to review the PSI evaluation in tab?
I have, Your Honor.
Yes, Your Honor.
Any objections?
None from the state.
No objections.
Any witnesses state?
None from the state.
Defense, any witnesses?
No, Your Honor, just Mr. Toriano.
All right, do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Lindsay Rodriguez.
All right, you may proceed.
Thank you. Mr. Toriano, we talked before you came up here today, correct?
Yes, sir.
Earlier today.
Yes, sir.
Okay. And I discussed the pre-sentence report and everything that was in it, correct?
Yes, sir.
Now, in terms of the events, do you accept responsibility for what happened?
Yes, sir.
Was it your fault?
Yes, sir.
Yes. You have been on probation in the past, correct?
Yes, sir.
A number of times.
Yes, sir.
And have you completed all of your probation successfully?
Yes, sir.
I think you had one prior felony probation that you were on, correct?
Yes, sir.
And you completed that.
Yes, sir.
And your misdemeanor probations, you also completed those, correct?
Yes, sir.
Have you ever been to prison?
Never been in prison, sir.
Okay. Were you employed at the time of this event?
Yes.
And how long had you been employed?
8 years.
And do you believe that you could get a job if you were placed on community supervision fairly quickly?
Yes, sir.
Is it your habit to keep employment for a long time or a short time?
For a long time, sir.
Okay. Now you have family support, correct?
Yes, sir. My 87-year-old grandma, she's here.
Okay.
And I'm uncle also.
And so your grandmother and your uncle are here in court today in support of you, correct?
Yes, sir.
And your grandmother is 90, correct?
87.
She's 90.
Yeah.
Just spoke to her. She's 90 years old and she's here today.
Yes, sir.
And your mother was not able to attend, is that correct?
That's correct.
Because she's in California.
That is correct.
But you have a good relationship with her.
Yes.
So you have a lot of support. Do you tell the judge why you think you could succeed on probation?
I can succeed because I want to be there for my grandmother and my family, and I just want to move forward with my life and continue my career as a network technician. I apologize for anything that's caused, and apologize to everybody, and I love everybody.
Do you have any substance abuse problems,
No.
drug problems, alcohol problems?
No.
Okay. You're a high school graduate, correct?
Yes, sir.
And you were also contending, or did you attend technical school?
Technical school, 2 years.
And counsel, I'm so sorry to interrupt. This is what I want to know.
Mhm.
Because he's applied for probation on a violation of bond protective order, assault, stalking. I want to know why he won't leave this lady alone, because it appears she doesn't want to be involved with him anymore. So that's what I want an answer for, because we're here because there was a court order in place saying you were not to have any contact with her. The stipulations were that she was out with friends. You all were not together and you followed her and you wouldn't leave her alone. This is what you stipulated to, right? I want to know why he won't abide by court orders.
No, Your Honor. I apologize about it.
No. I appreciate your apology, but that's not what I need. I'm trying to figure out why, because a court has ordered you not to have contact with her. According to what you stipulated to, she was out with friends and you were stalking her, you were following her, you violated the bond, the protective order.
Yes, Your Honor.
I want to know why he's violating the protective order, because that's an order, right?
Yes, Your Honor.
And it says you are not to do certain things. And according to what you stipulated to, you did those certain things.
Yes,
If I were to place you on probation, I'm going to order that you do certain things.
yes,
So
Your
I'm trying to figure out why you didn't follow the previous order.
Honor.
What do you mean it was a mistake?
Mistake. How we were talking. That's
Well-
the reason why I was put it up.
There's an order in place. You're not supposed to do that. Are you saying you didn't know about the order?
I didn't know about it.
All right, so then it's not a mistake that you talked to her. You knew about the order and you started following her. I'm trying to figure out why you're doing that.
I was in love with it.
I'm sorry, what?
I was in love with it, Your Honor.
All right, and how old are you?
43.
All right, you may continue.
And I did want to point out, Judge, that based on the stipulations, I don't dispute what the court's saying. However, there's also, and I reviewed it before coming forward today, that she went to his apartment and it was at his, from the bar to his apartment, and she doesn't indicate that she was forced to go there.
Okay,
So she was there, and then he was there, and of course, he was in violation of the order. Do you believe that you have learned that what you did was wrong?
Yes, yes, sir.
Will it ever happen again
No, sir.
with that woman or any woman or man
That is correct.
that has an order in place that you cannot be around them?
I understand.
Will you do it again?
No, sir. No, Your Honor.
Do you believe that part of your motivation was your emotional attachment,
That is correct. Yes, sir.
but now your brain is involved, correct?
Yes.
Your reasoning is involved. Will it happen again?
No, sir.
all right, so this is what it says in the stipulations. Making location, I spoke with victim one who stated that she went out to a local bar with friends. And that is where the original contact with S1, your S1 suspect, occurred. Victim stated that she did not invite or notify the suspect of her location, and the suspect follows and stalks her. Suspect made contact with her and told victim that she needed to go back to his residence to pick up some clothing that belonged to the victim. The victim went to the suspect's location, and victim stated that she got into an argument with the suspect. Victim stated that as she tried to leave his residence, suspect began to make physical contact with victim and bit victim on her right upper arm. Victim attempted to leave the location and rushed down the stairway. Victim stated suspect dragged her up the stairway in an attempt to prevent victim from leaving. This resulted in victim getting bruising on her left leg. Victim stated she then left the location, and that is when she called the police to notify them of the incident. Those are the stipulations. All right, this is what the court is going to do. Court is going to find you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. Taking consideration 2025 AL 007223, 2025 CR 01007. There's affirmative finding of family violence. There's to be no contact with the complainant, and the court will give you credit for any time served. The court will recommend therapeutic community to address any mental issues. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, so we are off the record. What I can tell you is the complainant no longer wants to be in a relationship with you. When you're released, if you have any items of hers, you know, drop them off at the police station, wherever it may be. You
So I
understand?
move on with my mom. So
Okay.
I just want to go to California.
All right, good luck to you. And counsel, if you remain, state will give you the dismissals.
Oh,
Thank you.
Triano?
Defense,
then a Callahan defense.
are you Mr. Garcia?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
I'm sorry, can I have that back, counsel, the trial court? State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Garcia, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with burglary of a habitation. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Do, Your Honor.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Honor. No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Deputy Law. Deputy Law, off the record. Will do. Thank you. All right, we're back on the record. Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Do you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $2,000 fine. State is silent on your application. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and rules upon by the court. Did you understand?
Yes, ma'am, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that you have no contact with the complainant. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation? To the offenses charged, how do you plead?
Guilty.
State, any evidence?
The doctor states one in acceptance.
No objection.
All right, state, you may be excused. Did you review this waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We can go off the record. Council, if you want a PSI, it's gonna be 8 to 12 weeks. If you just want a short resets, we can bring it back at the beginning of December and you can have witnesses or whatever evidence you would like presented.
Short one, Your Honor.
All right, Ms. Ferguson, I need a reset date for sentencing.
We can do January 6th,
No, beginning in December.
beginning of December 10th. Or January, December 4th.
All right, December 4th. All right, probation, there's no PSI. Thank you.
Thank you, Judge.
All right, Deputy Laura. Good morning.
Good morning, Your Honor.
All right, so thank you for dressing appropriately for court.
Yes, ma'am.
All right, so where are we on discovery?
Judge, I believe all the discovery has been tendered. I did not make an offer at this setting just because I need additional time to speak with the complainants in the case. And I will be prepared to make an offer at the next setting.
All right, Ms. Ferguson, I need a 30-day reset.
December 18th.
All right, once you sign the reset form, you'll be excused.
There's one other thing that I put on the note, Your Honor, that I'd like to address for the court,
Yes,
which is the GPS.
all
That
right.
he's had, and I did file a motion way back in
All
April.
right, could I see the motion for GPS? And what are you going to be requesting with regards to the GPS?
For two things, one, waive fees, and two, just that it be removed. He's had no violations on it. He doesn't have any criminal history. And I did confer with the state about it also. I did actually confer with it previously several times, but we also addressed it today.
All right, and state, are you going to be objecting to the removal?
To the removal, yes, the state's position at this time is that we are amenable to agree to a curfew to allow the defendant to address, I guess, the concerns or the hardship that he's expressed in counsel.
And Judge, I
right.
would like to, I'm sorry.
What are the issues
I prefer to,
the GPS?
I would love to go into that, Your Honor. I just prefer to do it off of social
mean, is it-
media.
Is it like he has to work?
No, it's more, it's deeper than that, Your Honor.
So is the curfew not going to be,
It's part of the work, but it's also the care that he has for an 8-year-old, that he's the sole provider for an 8-year-old, and I can go into why he's the sole provider. I
Alright,
just
so
prefer to do
here's my
that.
question. Do you have objection to tracking?
Judge, at this time, we would just request the curfew. I think that would be able to address the concerns.
All right, if y'all want a hearing, I'll give you a hearing. Otherwise, I'll agree to a curfew with hours and you all figure out what hours that will address his issues. Otherwise, we can have a hearing. I will hear whatever issues you all want to address.
If the court wants to do tracking for now, I guess we can do that for now, Your Honor, and then reassess
The
it.
state is not agreement with tracking, their agreement with curfew. And what I can tell you, sir, is this is what I do. Number one, I'm not the one who put GPS on you. That's a magistrate judge who did that. Now, the magistrate judges, when they place GPS on you, they've heard some information about your case. I haven't seen any police reports or anything about your case. The only thing I know is what's on the docket and what you're charged with, right? So obviously they heard some issues about your case and they decided that GPS was appropriate. So in my court, there may be some cases where sometime I'm like, I don't understand why they would put GPS on this type of case. But again, they probably heard some issues that I haven't heard. So what I usually do in my court, of course, I keep an open mind about everything. But usually if somebody's been on GPS, the next phase I'll do is I'll do curfew. And then the next phase tracking only. And then the next phase may be removal. But if you all want to present me with some evidence, and I will tell you, the state will probably want me to review a police report or something for me to make a decision on whether or not GPS should be removed, I'll do that. It's completely up to you all.
What I would confer with him about it, Your Honor, but what I would suggest is, if we're not gonna have that hearing today, maybe we'll just agree on some sort of curfew with, but.
Oh, we can
with the
have a hearing today, but the state is saying that they will agree to a curfew. So you tell them what the hours are, and that's just what it is. It's a curfew. And so, for example, for your employment, you tell them what your employment hours and they'll set the curfew. If there's some other issue with custody or anything like that, you tell them what the hours are, and that will be your curfew. And what I can tell you in this court, anytime there is a violation of pretrial services, the conditions you have with pretrial, normally that will come to me. The only time it doesn't come to me first, if it's some kind of emergency and it's after hours, like it's at midnight, because the courthouse is not open at midnight, then it will go to a magistrate that's on duty. And let me just tell you what those emergencies usually are. Somebody has cut off their monitor. And usually with that, they try calling the person who's on a monitor first before they issue the warrant. And then ultimately what ends up happening, even if they issue a warrant, I still have the chance to overrule that if we determine something unexpected happened, okay? All right, thank you.
She said for discovery.
Yes, discovering the state to tender an offer. And Mr. Rios, Mr. Rios,
Yes, ma'am.
just remain in courtroom until you sign the reset form, okay?
Okay.
All right, thank you.
If we decide to have a hearing, you said we can have it today?
Yeah, if you want to have a hearing.
Okay. I would, but I would make one request. If there's gonna be sensitive matters that I would.
PTD.
Okay.
So,
Pronounce your last name.
There's an extra I in it.
Oh, okay. Thank
yeah, that's it. Yeah, I was thrown off by that too.
you so much for dressing appropriately for court. I really do appreciate that.
Sure.
All right, Ms. Ferguson, I need a PTD date.
I can do December 18th.
All right, so it's going to be set for December 18th. Counsel, if you make sure that everything is filed today.
Yes.
All right, once you sign the reset form, you are excused.
Thank you.
Make sure you follow through on everything that they're asking of you, okay?
Yes.
Thank you. Are you Mr. Mendez? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mendez, did you review what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure
Yes.
with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, do you have a right to have a grand jury indict this case and make a decision on whether or not there's sufficient evidence to hold you over for trial? You also have a right for your attorney to have 2 days pass once they're presented with the information and 10 days to prepare for trial. Did you understand? By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Court will find that the defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
We do, Your Honor.
State you're proceeding on the information as presented.
Yes, sir.
Mr. Mendez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with unlawful possession of a firearm by a felon. That's the 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering that plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Mendez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine, no applications. This will run concurrent with 2020 CR 2487. State will take in consideration 2025 PF 37392, 37393, 37395. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Not in this case, Your Honor.
Then to the offenses filed, how do you plead? Guilty, not guilty, or no concept test?
Guilty, ma'am.
State any evidence?
It offers states one.
Any objections?
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, but I do have a request in that regard, Your Honor.
Yes,
And it's concurrent with disposition of the MTR.
yes.
As the court is no doubt aware, the last legislative session amended the Code of Criminal Procedure, Articles 27.20,
Yes,
concerning the necessity for confinement upon plea of guilty or no contest.
yes.
I've submitted written briefing to the court that I filed just yesterday afternoon in support of the request for allowing self-surrender of Mr. Mendez. In my reading of 2720, it appears that the mandate, the shall, concerns offenses enumerated under Article 42A.054, or what we call our 3G offenses. Mr. Mendez's probation, as well as the new case that he's pleading to today, are non-3G offenses. I'd submit to the court that Mr. Mendez has been strictly compliant with the conditions of bond in this case. He self-surrendered promptly when an MTR was triggered by his new arrest. He's been to court, he's been reporting, he's been compliant with conditions imposed as part of his bond. The ask is that because Mr. Mendez, and it's really a twofold basis for the request, he's a small business owner where he's been diligently trying to get things in place to allow the business to continue operating while he's in. It's a moving company, a pretty successful one. And 2, he's the father of a 12-year-old. We'd asked for 45 days to allow him to have one more holiday season with his daughter before he goes in to serve his time. I think he's demonstrated a willingness and obedience of the court's orders. And so we'd ask for the court's mercy in granting that request, whether it be a sentence today with self-surrender or reset for sentencing so that the court could expose Mr. Mendez to a fuller range of punishment for a failure to comply. So our kind of alternative requests.
All right, Mr. Mendez, you're currently on deferred adjudication for a first-degree felony. So the the request for self-surrender will be denied. The court is, as previously stated, the court is finding you guilty. The court will sentence you to 5 years in the prison. There's a $2,000 fine, time and money to run concurrent. This will run concurrent with 2020 CR 2487. Take in consideration 2025 PF 37392, 37393, 37395, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. All right, let's move on to the motion to revoke. Counsel, did you do a trial court certification on the motion to revoke?
I did, Your Honor.
Court is calling 2020 CR 2487. Could I have parties announced for the record?
Christian Noon for Mr. Mendez.
Mr. Mendez, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Christopher Mendez who was placed on community supervision in 2020 CR 2487 for the offense of manufacturing, delivery, a controlled substance penalty group 1, 4 to 200 grams?
Yes, ma'am.
All right, state.
Violation of condition number 1 on or about the first day of September 2025 in Bear County, Texas. Defendant Christopher Mendez committed the offense of unlawful possession of a firearm by a felon in violation of.
How do you plead to that?
And we waive and abandon our opinion here.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, sentence you up to 5 years in the prison and up to a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition number 1? All right, court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, it's to grant the state's motion for both the defendant's community supervision and sentence him to his underlying 5 years in prison to run concurrent with the case.
All right, and what was the previous case number?
2025 CR 014524.
All right, Mr. Mendez, are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, the court will follow your agreement. The court is finding violation of condition number 1 true. The court will sentence you to 5 years in the prison. This will run concurrent with 2025 CR 014524. There's a $1,500 fine, time and money to run concurrent, and the court will give you credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Mendez, sometimes, hands are tied, right? But I want to let you know, I do appreciate your turning yourself in. I appreciate your showing up on time, and I appreciate your being dressed appropriately, even probably knowing beforehand that you had worked out an agreement for prison time. I wish you the best, okay? You're welcome. Who else is ready?
May I present the TIC dismissal?
Yes.
Thank you, Judge.
The second seat, Judge. Keep on page 9. 92 down.
All right, Ms. Rodriguez, has anyone promised you anything other than the plea bargain agreement?
No,
Are you satisfied with the way you've been represented?
yes,
If you're not a U.S. citizen, by entering this plea, you will be deported and denied naturalization and reentry. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at 85 days in the Bear County Jail under 1244. There's an $800 fine. There's restitution of $2,817.58 to the city of San Antonio. Did you understand that to be the plea?
yes,
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There are not.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Your first state's exhibit 1 and all of that.
No objection.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? I cannot hear you.
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
My client deeply regrets her mistake, and we ask him to help us with that.
All right, why are you not walking on the sidewalk?
well, because I was crossing the street and I know I shouldn't have done it, but. Was no about.
Well, here's the thing. You're saying that you were crossing the street, but what you stipulated to, it wasn't that you were crossing the street. It says that you were not on a sidewalk and sidewalks were provided.
Yeah, but I was crossing the street. I was waiting for them to pass. Instead
All
of-
right, were you crossing at a cross point, or were you crossing in the middle of the street? No what?
No, I wasn't and I was walking across the street.
All right, so here's the thing. When people are crossing the street, there's a light, right? And you're supposed to cross where that light is, not in the middle of the roadway. So my question is, were you crossing in the middle of a roadway or at a light?
Roadway.
All right, so that's not allowed. And if you would have been hit, it would have been, oh, well, because you're not at a light or a crosswalk. You understand?
Yes, ma'am.
All right, the court is going to follow your agreement, find you guilty, sentence you to 85 days in the Bear County Jail under 1244. Give you credit for any time served, an $800 fine. Time and money will run concurrently. There's to be restitution to the city of San Antonio. In the amount of $2,817.58. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, make better decisions, okay?
Yes, ma'am.
All right, good luck to you.
Okay, thank you.
You're welcome.
Thank you, Your Honor.
I'm sorry, do you have a copy of the state?
Oh, yes. There.
I'm ready to proceed.
All right, state.
Violation of conditions of return. on or about the 19th day of June 2025 in Zurich County, Texas, the defendant Spaniard Faith Gutierrez did then and there fail to submit to the drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure.
And then violation of condition number 2, on or about the 30th day of September 2025 in Bear County, Texas, the defendant began to take Gutierrez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure.
We wait again in our.
Any objection to the waivers?
No, Your Honor.
Did you understand by pleading true to violations 2 and 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violations 2 and 2? All right, is there a proposed agreement?
Judge, what the agreement is for the court to deny the state's motion and alter and amend the conditions to include a no harmful or injurious contact order with Angelina Longoria and permit the defendant to buy out her community service hours at $7.25 per hour for service before it expires.
All right, we can go off the record.
When the court wants the warrant and everything kind of proceed, all of the previous technical violations that have already been worked through and counseled kind of appear on there.
Okay, all right. Ms. Abrams, so the 2 and 2 that she's pled true to, that's already previously been addressed?
So, on the first number 2, the June 19th, she submitted a negative urine test on June 27th. And then a subsequent negative on July 22nd. The September 30th was not addressed. We don't have anything after July 22nd. But I can say there have been a few failure to submits, but overall, there have been more negative urine tests than anything, than failure to submits. If that makes it.
And
And Your Honor, at my direction, she did get a drug test last week as well. That came back negative.
okay. And then who is Angelina Longoria?
Her spouse.
I'm sorry.
So Judge, Angelina Longoria is the co-defendant in the case, and she is also on probation. However, they are legally married, and back in July, a compliance hearing was conducted, and we amended conditions for her to include a no harmful or injurious contact with Savannah Gutierrez, and she could not live in the household with Ms. Gutierrez. At the time, I don't believe the court was aware that Ms. Gutierrez, or it didn't come out that she was also on probation, or the court was not reminded that she was also on probation and had the no contact. So when the supplemental report was sent in, the no contact, the no harmful or injurious contact that had been amended on the other party was not even mentioned in the supplemental report. So it made it seem that they were just having contact with the no contact order still in place, which it was, but it had been amended on the other party.
Okay.
So the supplemental report gave direction for an MTR to be filed. And when the MTR was filed, they included these technical violations. Ms. Gutierrez was going to, the court indicated if she finished her trade school, that she would be given credit for community service hours. She did not finish the trade school, hence the 95 hours are still outstanding. All of the fees and everything has been paid on the case, and she's been overall compliant with these issues. So probation stance at this point is to allow her no harmful or injurious contact with her spouse and to buy out the community service hours. Her case is set to expire on the 1st of December.
Okay. So you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, why are you not taking your drug test at the scheduled time on the scheduled date? This whole thing about doing it after the fact, that's not good.
I just think he worked Monday through Saturday, nine to three, so. Sure.
All right, so why, did you pick up the phone and tell your probation officer that? Probation, has she been telling them that she works?
Judge, one moment, I can look. Judge, I don't have a quick way to look at that. If you would like Mr. Marino to zoom in, I can have him zoom in, Judge.
No, that's fine. Oh, no, he doesn't have to zoom in. All right, so here's the thing. In this court, communication is key. That's the only way you're going to successfully complete probation. I tell people all the time, if there's an issue, you need to let your officer know about it. If you feel they're not addressing it, you come to me and we address it. You understand? All right, this is what the court will do. The court will follow your agreement to deny the motion. Alternate man conditions. I'm going to extend her for 2 months. Those 2 months, you better make every UA and do everything. You understand? And probation, she can do the UA or she can do the patch. It seems like she may be able to afford the patch. There is to be no harmful or injurious contact with Angelina Longoria. You're going to have to complete those remaining 95 hours of community service restitution, or you can pay it off at $7.25 per hour. Usually I say make a donation to the food bank because usually the food bank, they're always low on items for people. So if she wants to make a donation to the food bank that equals the $7.25 per hour, she can do that. All right, is there anything else? Probation?
Judge, as far as the UAs are concerned, with the extension of 2 months, typically we just do monthly. Are you asking for just monthly?
Yes, or she can do the patch.
Okay.
Is there anything else?
Just the patch.
The patch is approximately 300. But the patch costs more, but it helps you with your time.
Yes.
All right. All right, don't come back again for this, you understand? I'll keep an open mind, but I'm telling you, don't come back for it. All right, good luck to you.
And Judge, I just want to make sure that we are perfectly clear on the amended conditions for the other case. It says they cannot live together. Is that still the case?
Yes.
Okay, still the case. Okay.
Thank you, Your Honor. That
And
was my case.
as you know, there are reasons why I said that you all could not live together because there were issues. You understand?
Yes.
All right, State, do y'all have your, you're excused and the warrant is recalled?
Is there any other paperwork that she needs to fill out?
No.
Okay.
All right, and State, do y'all have the computer that's, okay, all right, thank you. Anyone else ready?
Yes, ma'am. Page 11, read down, Vargas.
And are you Mr. Vargas?
Yes, ma'am.
All right, defense has filed a motion to set bond. The defendant is on deferred adjudication. He is entitled to a bond. Of course, there are exceptions to that. So have you all agreed on a bond amount or no?
We have not. The state has made a recommendation of 20,000, Judge. I would like the court to take into consideration that Mr. Vargas has been on basically 2 years probation for 6 years. And that he has now turned himself in voluntarily, surrendered himself. He wants to get this thing behind him, so he's certainly going to show up for court. I just think 20,000 might be a bit excessive.
All right, so he's probation for 4 years because he was on probation for 2 years, extended for a total of 2.
Yes, sure.
All right, so you want to call somebody to present evidence on the bond that is appropriate?
Your Honor, I'd be happy to call my client.
All right, Mr. Vargas, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jonathan Vargas?
All right, defense, you may proceed.
Mr. Vargas, are you married?
No.
And do you have a child?
Yes, I have 6.
I'm sorry,
I have 6 children.
6 children. And is the mother of one of those children, do you live with her?
Yes.
Okay. What is her name?
Gabriella. No.
Okay. And what do you do for a living?
I have a business. I mow lawns. It's called Loyalty Lawn. And I take care of my child, Elias,
Okay.
and Julian. Well,
Okay. And then what does his mother do for a living?
she works for CBS. I don't know the right term she does, but she works. She works for CBS. I don't know the right term.
Okay. CVS
Yeah, CVS
pharmacy.
Pharmacy.
Okay. And does what kind of resources do y'all have in terms of money?
She works with CVS. I got loans. My family helps me out. If I ask them for help.
Okay.
But I'm always looking for ways to make money for my family.
Okay,
Yeah.
but in terms of like right now, do y'all have any savings?
Not at all.
Do you have a vehicle?
Yeah,
Is it paid off? Does how many vehicles do y'all have?
just one.
Just one between the two.
Yes.
And then you also take care of your child, correct?
Yes.
Are you,
That's-
when she goes to work, are you the full-time
Yes.
caregiver for that child? And I'm sorry, do you have any other resources financially besides I guess your income from mowing lawns is kind of
Yes.
sporadic, is that
Yes,
right?
it is.
Okay.
Correct.
And then her full-time income is, she works full-time for CVS.
Yes.
And besides those, how much does she make?
Month, I would say. About 2,000.
2,000 a month? Okay. And how much would you estimate you make monthly from their lawn care fees?
$500.
$500 a month? Okay. So very sporadic.
Yeah.
And do you have the ability to make a $20,000 bond? Right now?
Oh, no, I don't.
Okay.
No.
Do you have the ability, would you have the ability to make a $10,000 bond?
Yes.
Past witness, Judge.
Yes.
Question.
If you got your own landscaping business and you said workers for that point,
Yes.
so how often would you say?
Excuse me, just a second. That's okay. You continue.
So how often would you say you get jobs for?
Mm,
A month?
On a monthly basis,
How many jobs would you say you're gonna on?
6.
6 months?
Yes.
Okay. You said you're getting 6 children, right?
Yes.
Are they all with the same mother?
No.
How many, I guess, mothers are?
I have
there for the
5
children?
mothers and 6 children.
5 mothers?
5 yes.
Okay, do all 6 children reside with them? Sorry.
No, they don't. Only 2.
2.
Yes.
And where are the 4 reside?
With their mother.
Two.
With their mother. Yeah, they have different mothers.
So each mother has a.
Yes.
Okay, thanks.
Uh-huh.
And, okay, your wife worked at CVS?
Mhm.
Is she a pharmacist or is she just like a cashier?
No, she works on the computer. She don't do neither of those. I guess she does like data.
Okay, you said she makes 2,000 a month?
Yes.
Okay. You said you got family supports, correct? Other
Correct.
than your wife,
Correct.
who in your family would be able to help support you financially?
Let's see, my grandmother, my mother, my stepdad, my mother-in-law, my father-in-law.
And your in-laws?
Yes, I have a really good family support.
Mm. Does your grandmother work?
Yes,
Where's she from?
she's actually in this room.
She's what?
She's actually in this.
Oh, I understand. Okay, so where she just the lady?
She works for a doctor. She works at, I don't quite know the name, but she works for a doctor.
She like
She's a medical assistant, yes.
Okay, and what about your mother? What does she do for?
She,
Or is she employed?
yes, she is.
And what does she do?
I'm not quite sure, but
One. And your stepfather, is he employed?
yes,
What does he do?
he has his own business as well. He does
What kind of business?
free, free, he makes logos, I guess.
Logos?
Yes.
Okay.
I don't know the right term for it, but
And then your mother and your father-in-law, are they employed?
yes,
What do they do?
a teacher. Another one works for Sony.
Is it your mother-in-law that's a teacher? Or your
Yes, mother-in-law.
mother-in-law's a teacher and your father works for Sony? Or
Yes.
father-in-law? Do you have any estimation as to each of those persons' monthly income?
I don't.
I'll put that up, John.
All right, thank you. This is what the court is going to do. The court is going to set your bond at $10,000. There's to be no contact with the complainant. There's to be random UAs. The court will waive fees. This is going to be set for a contested hearing on December 9th.
And Judge,
All right, has he been on have you been on GPS?
No, ma'am.
All right, what is the purpose of GPS?
Given the fact that the warrant was 2 years old and it took him 2 years to address
well, Judge, that it took the state 2 years to address that, and that's, I think, what we'll take up at the actual contested hearing. But it's the state's duty to go out. He wasn't hiding from them. He wasn't actively hiding. They just didn't exercise due diligence.
All right, so it's going to be partial GPS for employment and the fees will be waived.
I'm sorry, I didn't hear.
Partial GPS for employment and the
Oh, so when
fees,
he's out.
and the fees will be waived. No, they'll give him a GPS before he's released from custody.
But his employment is like landscaping, so it's.
Yes,
Very-
he's allowed to do that.
Okay. And
All
then,
right.
Judge, I also wanted to ask on the
Yes.
no contact order, that's his. The
Doesn't
victim
he
in
already
cases,
have a no contact order with the complainant?
no. He lives with her.
All right, so we need to check that, but your contested hearing is going to be for December 9th. If I can get a reset form for December 9th for a contested hearing, please.
Thank you, Judge.
All right, step aside. They'll see if there's a no contact order that's in place.
Okay.
If there's not a no contact order, then there will not be a no contact order now unless there's some information that is presented to the court that there should be. All
Thank
right,
you.
thank you.
Thank you.
Morning, Judge.
Morning.
Judge, Mr. Crenshaw has two attorneys.
Oh, Mr. Crenshaw, come down.
I was appointed to a evading with a prior. It's a
Mhm.
felony, but Mr. Crenshaw also has several second-degree felonies that are
Yes.
slightly more recent and were appointed to Mr. Garcia
Mhm.
that are awaiting indictment.
Okay.
So I confer with the cases in totality. I don't know how the court wants us to proceed at this point.
All right. And do y'all have the evidence or discovery?
I have the discovery on my particular case, but not
On
on
mine,
this case.
we're still investigating, Judge. I think this is something we're gonna have to have a hearing on, either in front of Judge Nakata or here,
Okay, a hearing for,
suppression
on the unindicted matters?
and the unindicted matters, yes.
Okay.
It doesn't matter.
Judge, I don't know if it makes more sense to appoint all the cases to Mr. Garcia. He is on the higher cases, as they'll probably drive the bus with regards to plea bargain.
Well, I don't know. It depends on what happens to the other cases.
And that is true.
All right. So you have all the discovery?
On the one case, yes. Your Honor.
All right. All right. And was this, and the state you said wasn't prepared to tender an offer?
She's looking at-
Right now, the files aren't here, but in our system, but one of them is those 4 to 400 and it doesn't affect the council hours.
All right, Ms. Ferguson,
Yes.
recall this on February 18th and we'll see where we are. I'm sorry, not February 18th, December 18th.
Yes.
And we'll see where we are in all matters. All right, thank you. Do you have any questions about anything? All right, thank you.
He has a discovery.
Just put it as a status because he has new outstanding cases. And what I can tell you all, that 4 to 400 gram case, if they don't have their labs ready, they don't have their labs ready, your case will continue to move on. And I don't, you may want to ask the state if they can expedite that. All right, thank you.
Okay, thank you.
Thank you, Judge.
You're welcome.
He'll come see you. There sometime this week. Right? I'll look into it. No, it's not. My name is David Garcia.
Right. This is family violence. Right, today is plea deadline date,
It is, Your Honor.
and is an agreement been reached or no?
No, there has not, Judge.
All right, how long do y'all expect this trial to last?
3 days.
All right, if y'all will confer with Ms. Ferguson on a jury trial date and Mr. Alanis, your jury trial date is probably going to be in the new year because we already have murder trials that are scheduled at the beginning of December. And as you know, the holidays are upon us, so the court is closed on Christmas. We have Thanksgiving. So the earliest we'll be able to take you is probably in the new year. Do you have any questions?
That works.
No. All right, what date?
January 27th, Judge.
All right, and if y'all can make sure that the discovery acknowledgement has been signed.
Yes, Your Honor.
All right, thank you. And counsel,
Yes, Judge.
I guess it's not gonna happen.
That would be.
Probably like late December. It's winter.
Mhm. And I'm just waiting for Odyssey.
At least we're getting rain.
But is that really a good thing? Yeah.
They're like, we can't do fall, best we can do is humidity.
Yeah. Thank you for dressing appropriately for court. I appreciate that. All right, on this case, where are we on discovery?
There's potentially some surveillance footage that might exist that we need to reach out to witnesses on to see if it does exist and that is can see it to us. If it doesn't exist, I'll let defense know that. And otherwise, I think that I've disclosed everything else that is about the case to defense.
All right, and were you able to tender an offer? Okay. All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date.
December 18th.
All right. At that time, you'll need to let me know whether or not you've reached an agreement. Of course, if for some reason there's a video that's in existence and the state doesn't have it and your counsel doesn't have it, we'll change that, okay?
Thank you, Judge.
All right, thank you. Once you sign the reset form, you're excused. Good morning. All right, and there are no applications?
They're not, Your Honor.
Court is calling 2025 CR 0134228-02, State versus Lindsay Rodriguez. Can I have parties announced?
Roberto Ambrosino for the defense.
And are you Ms. Rodriguez? Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Rodriguez, did you review the true bill of indictment with your attorney? Did you understand it? All right, so I'm going to need you to speak up so I can hear and the court reporter can hear. Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Rodriguez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to go to trial. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
No.
I'm sorry?
Yes.
All right,
No.
so here's the thing.
You good with me?
Yes.
I need you to listen to my questions. I need you to speak up because I can't hear you.
Okay.
The court reporter can't hear you. You understand?
Yes, ma'am.
All right. Has anyone promised you anything other than the plea bargain agreement?
Yes.
What have you been promised other than what this plea bargain agreement is?
Oh, no. Nancy, no.
All right, so let me let you speak to her a little bit and then you all can come back up, okay? And I'll take you right back up.
Okay.